All right. All done with that. We move on to the discussion agenda. We have the termination of the tolling agreement. Matthew Gould, Town Attorney, and Don Stone, Breakwater Wastewater Department.
Thank you, Mayor. We also have Brad Simons online to provide some input. You may recall that issues were noted with the reverse osmosis plant back in the spring. And in order to address those issues, we bought some time on any possible statutes of limitation by signing and approving this tolling agreement. Well, the agreement that we signed gave the right to terminate to the parties on 30 days notice. That termination occurred. Both of the other parties have submitted notices of termination. And the reason is that the issues have been addressed. When I say they've been addressed, I don't have the knowledge to say that they've been fully resolved or anything like that, but they have been at least addressed. And to our knowledge, and I'll let Don and Brad talk about this, I'm not aware of any further work that needs to be done. Just a few key points that I want to highlight. Let's see. Dates are important here. And I don't want to provide any kind of, legally binding commentary, but the termination date of the tolling agreement is September 24th, which is only 10 days away. The board should consider that that would be the running of the statutes of limitation. Repairs have been made. Don and Brad can discuss. Claims for any further repairs may be barred after the termination date. If the same problems recur after September 24th, then our options are potentially very narrow. I was looking at the law on this afternoon. There is something called the repair doctrine. It's unclear that that still survives in Colorado. There were several Court of Appeals cases, and then there was a Supreme Court case that seems to have at least partially overturned those cases. The idea there is if there is recurring repair for the same issue, that the statute doesn't run as it might otherwise. There is an estoppel to prevent the statute from running. But like I said, in Colorado, which has a provision for giving notice of construction defects, there's some statutes on that issue. The court said where the CDARA, which is the Colorado Construction Defect Action Reform Act, where it applies, the repair doctrine does not apply. Now, we have not given any notice under CDARA. We obtained through agreement just very roughly and it's some additional time that would be very equivalent to what we would have gotten if we under CDARA, maybe even more, maybe even a little more. Our options, if we're concerned about future failures, one of them is to file a lawsuit, and that means before September 24th. Another is possibly to submit a CDARA notice, because there is a tolling provision in CDARA. So that is those are the legal considerations here. I want Don and Brad to talk about the condition of the RO plant and whether there are any known issues, to file a lawsuit over or to submit a defect notice in regard to. So go right ahead, Don.
Good evening. Right now it's working great. We got our first round of tests. I'm doing the discharge monitoring report for August, and everything is good. The repairs they made, and Brad can speak to them as well. Before, when we had problems, they replaced the seal, bolted everything back in. This time they beefed up the supports, the mounting, and then when they bolted it back in, they also put angle iron supports on top to help clamp it down. So I'm fairly confident that it'll hold, but I'm not an engineer. But at this point it is working. And usually those failures were, 5-6 months down the road. So we really won't know for a while if it is going to fail.
Good question. Do we know if we had to pay to repair this, since we are no longer under any kind of warranty, approximately how much it would cost?
The repairs that they just did were, everything together was probably upwards of $75,000 to $80,000. they have to refabricate a lot of the parts to put them in. All the carbon media in the bioreactor has to be taken out. So you have to hire somebody to remove that. If it isn't stored, I don't want to say properly, if you store it over a period of time, it can go bad. The biomass can adhere to it and you can't clean it back up. It has to be replaced. That in itself is, $15,000 to $20,000 for the media. Once it's put back together, we have to reseed it with bacteria. So there's a few thousand more. And then there's a startup period of about 30 days to get it running again. So it's not a cheap repair. They did pick up the tab for the first 3 failures. And then on the last failure, I think they were convinced that it was a design issue and they came up with a better design.
So they changed the design.
Mhm.
And if it fails again, we can still use the RO plant for mixing, augmentation,
Augmentation and blending.
blending.
We're looking at changing the water line that comes in from Central Well to town. And at the same time, we want to add another line that will go up to the tank. So regardless of whether the plant runs or not, we have that option to take that well water and blend it at the tank. Pick up a few extra acre feet a year of drinking water.
Questions from the board, starting with trustee Wakeman.
So in the letter that was included with our packet, it says that the written notice of termination was May 1st of this year. Is that a factor for us at all, or?
I'm sorry, I need to look at that. Which letter is this in?
It was included in our packet. It was this one, the second attachment.
Oh, is it the one that says hereby gives written notice of termination of the tolling agreement effective May 1?
Yes.
Okay, it was the tolling agreement that was effective May 1, not the termination. And I can tell you that the tolling agreement did take effect on May 1. It's awkwardly worded, but I'm highly confident that's what it means.
Okay. All right.
Because the sentence goes on to continue to refer to the tolling agreement, and it was effective May 1. So I think that's what they meant.
Trustee Lane, any questions?
No, just wondering, the gentleman that's been waiting on the Zoom call, does he have anything to say?
Brad?
Can you hear me okay?
Yes.
Okay. Yeah, I'm on this the call to add. I would have preferred to have been there in person, but unfortunately had other commitments with children. But Don did text me today and asked if I could participate in the meeting. I did a quick review of some of the information that Matt has assembled and presented, and a reading of the actual tolling agreement that was effective on May 1, 2022. I truly believe that the town staff has worked diligently to make the Frontier Water System Seahawk facility perform as intended, but has been challenged with non-structural issues in terms of water delivery and the ability to reliably treat water effectively. The structural issues have been the biggest issue. I believe there was in October of 2021 where we initially had some seal failures associated with the plates at the bottom of the basin that was causing some pitting because of water pressures that Stanek did come in and repair. Most recently, there was a major failure of the under-drain system, which Stanek has subsequently repaired. But it was during that time, I believe, that they introduced this tolling agreement concept to extend the consideration to potential lawsuits or notifications under the Construction Deficiency Act. I truly am concerned about the structural nature of the reactors, given the problems that we've experienced, and am concerned about the fact that in less than 30 days after the most recent repairs, they have both parties, Stanek and Evoqua, which was previously Frontier Water, had provided notification that they wish to terminate the tolling agreement. I know that I believe, and Matt is going to have to correct me if I'm wrong, that the tolling agreement dated May 1, 2022 allows for parties to terminate the agreement with 30 days notification. But I'm also going to point out that paragraph 10 of that tolling agreement, and remind you, I'm an engineer, not an attorney. But paragraph 10 says any notices under this agreement shall be given by email, hand delivery, or overnight courier services to the party's legal counsel set forth below, and shall be effective upon receipt. So Evoqua's letter is dated August 25th. I'm not sure when it was received, but it's addressed to Joe Drummond of Stanek and Leonard Wiest of the town of Milliken, neither of which is the party's legal counsel. Stanek Constructors' letter is dated August 30th. And again, I'm not sure when it was received, but it's addressed to Leonard Wiest, Cheryl Powell, and Luke Batcher. None of those are legal counsel. So if we need additional time to make a determination if there is litigation to be filed or notification of a construction deficiency, maybe we could get them to reissue these letters with revised dates that actually are sent to the town's legal counsel as the appropriate party under paragraph 10. So, Matt, do you have any comments on that?
We could certainly do that. When I actually receive a notice, that's what I treat as the effective date, even if it came through backdoor channels. I wouldn't have a problem sending them a letter. Hey, would you please direct these to me so that I can trigger the timeline? It would buy us 30 days. I certainly could do that. I think my inclination, if we think we need to try to catch some more time, grab some more time, probably the best avenue is to go ahead and issue a CDARA notice and base it on the fact that we can't confirm that this repair is effective for some time. We have to list defects in that notice, and then they have an opportunity to propose a solution, and then there's a clock that runs. I'm not sure that we would gain more than probably, 60 to 90 days. But that might be enough to help us.
I definitely think that would be enough to help us to make a determination and observe the performance of the most recent improvements, knowing that the first series of improvements did not resolve any issues, or maybe it did and there was a different issue. But I see a major design flaw in the bioreactors based upon the two incidents that I have encountered since working with the town once the facility was actually constructed.
I've got a question here. Okay, so you've got a design flaw and you had all these issues, and then they refabricated this part. Why isn't there a warranty period for that part? Why can't we ask for that? That would give us a lot more time than what you're talking about. This is kind of a critical thing. If we've had all these failures, we need some kind of a warranty on that newly fabricated part. Is that possible?
They could give us a warranty if they chose to. I think the perspective they have is that they're operating under the original 2018 contract. And they're going to probably take the position, look, we've gone over and above what we think we should have had to do in the first place.
Well, not if there's a design flaw. We are a pilot program, right? This has never been done before.
Well, there are other angles that we could potentially utilize if this breaks down again. For example, there's a slightly longer statute of limitations under the Uniform Commercial Code. I don't really view this as a Uniform Commercial Code transaction, but it's possible that we can find some case law that would support that. The Uniform Commercial Code statute of limitations is 3 years, but there's a very specific hard statute of limitations for actions against contractors and architects that is 2 years and this isn't the right term, but basically it's the date of discovery of the issue. So like getting the warranty extended is possible. We need to look for some leverage to try to pry that out of there.
Well, there's one thing saying that there's a date of discovery. There's another, I mean, it takes time to get through this process and to get to this new piece that they put in. So it should be from the time that it was installed. There should be a
Yeah, it just
period.
doesn't.
You know what I'm saying?
I'm just not seeing that it works that way.
Okay.
We're looking at a date that may be the date of discovery, and I'm choosing my words carefully, but that's what we're going by, and it's some time back.
Well, let me ask a question of that, Matt. The most recent defect which Stanek and Frontier had to remedy, what was the date of discovery of that problem?
Let me answer that question this way. There is an email that notes a pinhole, and that email is dated May 20th of 2020.
So if you could apply your case law or whatever term you're choosing to use to that date, then we would have a longer period of time to make a determination if we are, concerned about the longevity of this facility, not just in the light of its operational challenges and future effluent limitations, but in just the general structural nature of the bioreactors of which they provided and were constructed.
Well, I think if that is the date of discovery and a 2-year statute runs, then it ran in May and it was told by this agreement. If we have a 3-year statute, which I think is maybe we don't, probably we don't, then you're right, we would have some additional time.
Right.
And that's the original problem, not, do you think there's a date with this latest fix? Or
This is the date that we're going by.
This is the latest fix?
Yes.
Where they
The May of 2022.
it took them 2
No,
years.
May of 2020. I'm sorry if I misspoke.
So it took them 2
Right.
years once they figured out to redo all this.
Yeah. Isn't that timeline right?
I think there are two different discoveries.
Right.
The
That's what I'm
first
trying to
was in
say.
relation to a gasket failure that was causing pitting and certain problem, which they remedied. And then there was a subsequent issue with the overall under drain design, and it needed to be reconstructed.
Right.
Well, I'm happy to argue that the pertinent date, and remember, discovery is not the right word, but the pertinent date is later if we have some evidence to that effect.
Well, I would recommend to the town, and again, I'm just an engineer and I never want to represent that I practice law. But number one, that they did not provide the proper notifications because of the parties to which the termination letters were addressed to buy us more time to make a solid determination working with Don to determine this most recent set of failures, which is an entirely different set of failures from the May of 2020 remedy.
I would agree.
Yeah,
When does that expire? The 30 days?
The 24th.
24th of this month,
I mean,
10 days.
But
Yes, close.
again, because of the date of notification, but not notifying the parties in accordance with paragraph 10 of the tolling agreement, could we get that date reestablished, which will give us more time and not be under the crisis of 10 days and maybe give us another 30 days of.
Maybe. It's not the kind of thing I like to rely on, but maybe.
I think that's probably a good approach because right now I don't have a lot of confidence.
Okay. Well, I
Where we're
think
at.
what I'm discerning is exactly that we don't have a lot of confidence in that we'd like to, any protection we can find, we need to buy.
And we can't just pull out $80,000 from somewhere in our budget to fix this again.
Okay.
You know,
Can we ask them if there's a guarantee or any type of warranty that they would do on the new fabricated part?
Sure.
I think that needs to be included. Trustee Dean, comments?
Well, I think we need to buy as much time as possible.
Trustee Beckler,
Nothing further.
Mayor Pro
No
Tem Furley.
further.
Okay, so I think we've got clear direction.
Mhm.
Try to get the 30 days, try to get a warranty on the part and express our dissatisfaction with and concerns with the repair that we have now. They used this process though in mining operations originally, isn't that correct?
The selenium removal is a mining process. Our bioreactor was a redesign. So the parts that failed, the under drain used to be more of a manifold of pipe versus the plates that they have now.
Mm-hmm.
So that was a newer design that they did specifically for our footprint and our bioreactor. So it's yes and no.
Okay. Any further discussion? Direction for Matt Gould?